Good morning, good evening, and good night. Welcome to the Honest Judge Podcast. Honest judgments, honest thoughts. First off, let's introduce ourselves. I'm Matthew, one of your hosts.
I am Jacob, your other host.
And today we will be discussing the often cited Roe v. Wade case that the Supreme Court decided in 1973. The case was filed by plaintiff Jane Roe. Just for a little bit of background, Jane Roe is a pseudonym used to protect the identity of the plaintiff, so it's not her actual name. Roe sued the state of Texas for access to abortion, and Henry Wade took up the defense on behalf of the state of Texas. Roe argued that she and all of the women in the U.S. had a constitutional right to abortion that was provided by the 14th Amendment. The famous case was settled nearly 2 years later, with the court ruling in favor of Roe with a 7-2 vote, preventing states from making laws that restricted abortion access. Of course, we now know that the case was overturned and the court's previous ruling was reversed. This case, despite having been decided for the second time over a year ago, is still the source of a huge amount of debate and vitriol from both sides of the political aisle. The 14th Amendment states, and I quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Putting aside the abortion debate itself here for a moment, I would like to ask you, Jacob, what your general thoughts on the case are.
My general thoughts on the case is, well, I don't think the 14th Amendment really covers abortion at all.
Well, so the 14th Amendment, it's very interesting because this clause is often cited as protecting the privacy of U.S. citizens, when it doesn't seem in the actual text that people read is that it really talks about privacy at all. It refers to rights, and specifically the rights listed in the preamble of the Constitution, but it doesn't seem to specifically outline privacy, as it's often said that it does.
If you go back to when they were making it, they wouldn't have thought about abortion and things. I'm originalist, so I don't think they even thought about that and covered it at all.
Yeah, so obviously it seems more likely that whenever they're talking about whenever the 14th Amendment was written, it obviously wasn't about abortion because it doesn't specifically mention that anywhere in the text of the amendment. And additionally, beyond just that portion that I read, the other sections aren't related at all to rights in the first place. The other sections cover economic topics, the amount of representatives that the different U.S. states should have, readjusting them for untaxed Native American reservations. And it also allows Congress the fifth section of the amendment just allows Congress to pass laws that provide that. Obviously, I can sort of see the jump that one might make to suggest that the amendment provides for abortion access, but it doesn't seem to me like that makes much sense in the end. Like it definitely does not explicitly state it, but even implying it doesn't seem to me like the court's original decision made much sense.
It doesn't, because I don't know, we're at the text. Maybe they're reading between the lines or something but then again, they might be trying to catch it up with modern day text.
Exactly, and I think that's really where this issue gets its power from, or momentum, I should say, is that people like to interpret these laws in whatever way suits their narrative, and obviously I'm not totally removed from that. Personally, I'm very conservative, so it's I'm obviously going to lean towards more originalist ideas because originalist ideas are generally more conservative ones. But either way, it seems to me that the court's decision in the original case and also the overturning of the original case seem to both be highly political, in my opinion.
It really was. If they were being honest, I don't think the first time I don't think it would have got passed, honestly.
Well, but that's the difference, because I think that it just depends on which political party held the court at the time. And so personally, I'm against abortion. I'll just start with that. I'm against abortion in general. So if I was on the Supreme Court, I would have ruled against Roe and in favor of Wade, obviously. But if we're talking about how the court should have ruled based on the Constitution, it seems to me that the Constitution is way too vague on this stuff, so that's why the political stuff sort of gets in the middle, you know?
Yes, you can always obviously tell which one was political. Well, they both were political, but which one was liberal and which one was conservative. The first one was liberal, the second one was conservative. but this is most like all court rulings is political.
Yeah, especially, well, there's some court rulings that I think can definitely be traced back to actual constitutional amendments and the text of the Constitution itself. It just seems to me that whenever we're looking at the Roe v. Wade case, in both cases it must have been political because this amendment is, one, very vague, and two, it doesn't talk about privacy anywhere, especially not specifically women's privacy, because at the time that this amendment was written, that really wasn't a huge priority for people in the United States, though it should have been, obviously.
But during that time, women didn't have rights, period, and then neither did blacks. So
Yeah, at the time there really wasn't money. Like, our country was pretty unjust at the time, obviously. If we're looking back at the 14th Amendment, whenever it was written, so there is some level of, I think originalism is obviously the position that I more closely hold to, but if we totally held completely to originalism, then when we're looking back at the 14th Amendment, would that not mean that we are excluding black people from voting and women from voting? If we are against, so to play devil's advocate here, I should say, does that mean that if we're going to look at with an originalist view at the 14th Amendment, why don't we look at an originalist view in terms of the Constitution as it originally stood?
really, does it say where certain people can vote? I know it says citizens, but does it say male, female, black, or white?
It does specifically mention, so it doesn't go specifically into the race in this particular article, but it does appear to me, in the later sections of this one, it would appear to mention several things in relation to male citizens being able to vote. And it doesn't really mention women being citizens in this particular amendment. Obviously, that comes later. But if we're looking with an originalist view at this stuff, why is it... So, again, I'm playing devil's advocate here, so it's not... I don't think this way, generally. But if we were to say that we're looking with a totally originalist view at the entire Constitution and all of its contents, would that not mean that we are in favor of slavery and that black people shouldn't be able to vote and that women shouldn't be able to vote? Because that would be the most commonly heard argument from the other side in terms of originalism.
Not really, because, well, I'm mostly an originalist on the 10 Commandments. Well, not the Commandments.
Bill of Rights.
Bill of Rights.
Bill of Rights.
Sorry there. But honestly, I don't believe in slavery. I don't believe in any of that. But I am against abortion, and most of the time I am on the originalist view, except for some parts.
Yeah, so you see, with the originalist view, for me, it's more like because the originalist view applies to every piece of legislation that's passed. So specifically with the constitutional amendments, there are later amendments. So that, for example, I believe it was, what was it? The 19th Amendment, I believe, that allowed women to vote. I may be wrong there. I'm just spitballing off the top of my head. But if we look at an originalist view with that amendment, then obviously if we're originalizing that amendment, the original people who wrote that amendment think that women should be able to vote. So it's like we have to take into account not just what the Constitution says and what these specific amendments say, but what all of them say. And that's what I think originalism boils down to.
Yeah, I think you're right, Matthew, on that part. Does say in the Bill of Rights that women has the right to vote and women rights. But on this one in particular...
No, the 19th Amendment, not the Bill of Rights. It doesn't mention that in the Bill of Rights.
Oh, all right, sorry. 19th Amendment, I'm sorry. It does say women does have the right to vote. But on this one in particular, which we're looking at the 14th Amendment, does have nothing about abortion or anything that has to do with their argument.
Additionally, I would argue that this amendment, explicitly, I'll actually quote from it again. It says that no state shall make or enforce any law which shall abridge the privileges or immunities of the United States, and nor shall any state deprive any person of life, liberty, or property. Life, to me, abortion, in my opinion, seems to be depriving people of life, which we're sort of steering back to the abortion debate here, which is obviously like inevitable. We're obviously going to talk about that at some point in relation to this case. I mean, that's the entire reason that this case is relevant, if we're being honest. But in this particular amendment, it once again guaranteed, like, it reaffirms the right of all Americans to life. And in my opinion, that includes fetuses, you know?
Yes, I do too, but, well, there is no but. It does say life and the pursuit of happiness, and so I believe, well, if they don't want the baby, just put it in the foster care. Someone will take babies like nothing.
Yeah, and that's the thing, because people often complain about how the adoption system works in the U.S., but specifically the reason that it's so difficult to adopt, like, a newborn baby, is because there's such a long line of people waiting to adopt newborn babies that it's very difficult to get in there, you know? Because there aren't as many, there's not even close to as many newborn babies born and put up for adoption as there are families willing to take them in. So as we're sort of coming to wrap this up a little bit, how about we dig in a little bit closer to the issue of abortion itself? Just very briefly, what do you think, Jacob, is the strongest conservative argument for abortion, excluding the Bible?
Excluding the Bible, well, I believe in God with all my heart. But without the Bible, I believe the strongest argument is not really for sure, Matthew.
Well, so personally, for me, it seems that to be that whenever you're having to, would you agree that whenever you're trying to support abortion, you have to draw a line somewhere as to where life begins, you know?
Yes, obviously.
Yeah, and so it seems like the only line that we can really draw that really makes much sense is the line of conception. That's the only line that really makes much sense to me. Because if we draw a line, like for example, some like to draw the line at the heartbeat, but there are people who are only alive because of a pacemaker. So what do we do with them? Like, are we allowed to just kill them? Are they totally, like, not moral beings anymore? Like, do they have moral significance?
I believe that they do because they're citizens of the United States, which I believe. Even a baby still in the womb, I believe, is a citizen of the United States. So I think they should be protected by the law, too.
Yeah, and exactly, these laws, the reason that we're even able to have these kind of discussions is because the laws are somewhat vague on these issues. And so the laws don't specifically speak to abortion anywhere, and they don't speak to specifically children in the womb. And at this point, we're so politically charged that any laws that do say those things are going to be very specifically targeted to favor one side. So you can just call political bias. If the Founding Fathers had been more clear with this stuff, then we would be better equipped. But then again, they never really imagined that we would be having to deal with this kind of stuff, you know?
I don't think it ever crossed their mind once. I don't even think, maybe 100 years later, first time it was shown in the United States.
Yeah, like abortion was not a huge thing for a very long time, and it wasn't a huge thing in the U.S. For many, many years, and we weren't like the pioneers of abortion by any means. There were other European countries doing it before we were, and then we allowed it eventually because, some states allowed it because originally, and I think this all comes down to the overturning of Roe v. Wade is not necessarily an attack on abortion as a whole. All it did was take the issue back to the states where it belonged, you know?
I believe it belonged to the states, their opinion, because, well, some states might want more population in their state than others, like Wyoming. They obviously need more population, and areas through that area, Colorado and Utah and all of that, they have a very low population in which they don't get much representatives for it, so they might want more population for it.
Well, and that may be a potential motivating factor, but I think it's better for the state legislatures. And again, this goes even to an even deeper issue with, again, we don't really have time to cover, like, states' rights versus, or like, more federalism versus states' rights. But if we're looking a little bit deeper, then we can even trace this issue back to, in my opinion, or at least the Roe v. Wade case, not the abortion issue as a whole, back to states' rights, because states, in my opinion, should be the ones deciding this stuff, not the federal government. And ultimately, that's all the overturning of Roe v. Wade did, was send this issue back to the states. And, I mean, you think about it, more liberal states, like California, New York, Massachusetts, these places are not going to outlaw abortion, and there could only possibly be more abortion access. Like, there's not going to be less access to abortion because Roe v. Wade was overturned. Most of the people who are angry about this stuff are not even living in states where it's outlawed. They're living in states where they can go do it freely whenever they want, you know?
Exactly. I think that's a thing, though, because we're not as angry as it is, like, in Kentucky, because I don't think it's allowed here, right?
We have some restrictions on abortion.
Okay, we have some restrictions, but you can't go outside and just... There will be restrictions, but like Texas and all that, they aren't as mad as it because they're more conservative states, which they're outlawed it probably.
Well, it's not totally outlawed in any state. There are concessions made, obviously, for rape cases and obviously for any threats to the mother's life, obviously, but that's an obvious one.
Yeah, but then again, but you see in New York and stuff, they'll be mad at it because, well, there's no restrictions on it or anything.
Yeah, and they still don't have, and even despite how angry they are, there's no restrictions even attempting to be put on those people in terms of abortion. Now, would I like there to be restrictions in the entire U.S.? Yes. I just don't think that it's the federal government's job to get involved in this. I think the only way that we make progress on the abortion issue, as conservatives, I mean, is to like incremental change. So we're not just going to walk in there in very liberal states like California and walk into the state legislature and propose laws that outlaw abortion almost entirely, apart from rape and the life of the mother. We're not going to be able to do that. It's going to be slow, piece by piece, week by week even maybe, that we have to pull back the abortion restrictions until we get to that point. Morally, I think that there is an argument against rape cases being allowed for abortion, but ultimately I think that the only way, like, it's not realistic to say that we're going to get a law that outlaws abortion and rape cases, and really that is pretty inhumane in terms of the government standards. That's not really the government's job whenever we get down to that, you know.
I absolutely agree. I believe in rape cases should be an option for them in the mother's life, but also if you do have it with no protection, there's always a Plan B day after pill, but that's
Plan
better.
B day after pill is essentially just an abortion pill.
Yes, but then again, the baby hasn't really formed yet.
But again, if this takes it back again, if we're gonna look at, so again, that this becomes a part where you have to draw a line. When is abortion okay and when is it not? In my opinion, it's never okay. The moment that a baby's conceived, it becomes not okay. If you're gonna suggest that the Plan B pill is an acceptable way for someone to get an abortion, then we're just going back to, oh, the baby's not formed. It depends on, do we believe that life starts at conception or not?
I believe after 32 hours, it's abortion should be restricted.
So there is some amount of abortion that you would allow.
Yes, day after pill. That's it.
Day after pill. Okay. Well, I'm glad we got to have a little bit of constructive conversation. Although we're both very conservative, so it's a bit of an echo chamber. But I'm glad we got to have some constructive conversation here. This was the Honest Judge podcast. Honest judgments, honest thoughts. Thank you for tuning in.